Hello and welcome everyone to yet another episode of Law Scope. I am Sana and in today's video we shall be discussing the very recent judgment that allowed Jalikattu and the other bovine sports and events which are related to basically all these the Tamil Nadu, Karnataka, etc. The competitions that are related to those areas and using bovine animals. So the name of the case is Animal Welfare Board versus Union of India. Earlier, Animal Welfare Board was a party to it and it was essentially a clubbing of petitions. But then the Animal Welfare Board understood what was the stance of the central government in this case. So there was a little change in the changes in the parties. However, it so stands that the name of the case will still be the Animal Welfare Board versus the Union of India. It is a constitutional bench judgment and it automatically therefore becomes an important judgment for you to cover in exams, etc. And the judgment was, the bench was led by Justice K.M. Joseph, who retired very recently, Justice Anirudh Bose, Justice C.T. Ramikumaram, Justice Ajay Rastogi and Justice Rishikesh Roy. So this was the 5 bench that constituted the judgment. So the judgment is essentially about the bovine competitions that take place in certain states of Tamil Nadu, Karnataka as well as Maharashtra. When we talk about how and why and under what circumstances these competitions should be allowed or these competitions should not be allowed, the main legislation that comes to our mind is firstly the Constitution of India that gives rights not only to humans but also to animals, and secondly Prevention of Cruelty Against Animals, the Act of 1960. You might know that last year in April 2022, it was a news that the first country in the world to give legal rights to animals, to wild animals, was Ecuador. But what is the status of animals and animals' rights in India? Well, in India, animals have not been given rights as such, but the state as well as the citizens of India have been conferred with the duty to protect animals as well as to prevent cruelty against animals. So they do not have a right per se, they do not have legal rights, but at the same time, we have a duty to ensure that they are protected. So if we talk about the act is the principal act that is preventing cruelty against animals. The act is to prevent the infliction of unnecessary pain or suffering on animals for the purpose of to amend the law relating to the prevention of cruelty against the animals. So this is essentially under entry 17 of the concurrent list. Our concurrent list is the list under schedule 7 of the Constitution of India. There are 3 lists: the union list, the state list as well as the concurrent list. If this is in the entry 17 of the concurrent list, then that means that on prevention of cruelty against animals, the central government can also legislate and the state governments can also make legislations on related to basically prevention of cruelty against animals that are state specific. Now, if we talk about the specific provisions, the first provision that we need to discuss before discussing the judgment is section 11 of the Prevention of Cruelty to Animals Act, and the section basically states that no one shall beat, kick, torture, overload animal. Overload as in the case if they're like donkeys or horses who are pulling carts and they have cargoes on them. So nobody is going to overload it. Nobody is going to employ for work any animal that is already diseased or infirmed or is wounded or any due to whatsoever reason it does not have the capacity to be employed in that manner. So nobody is going to be cruel to animals while animals are being employed for work. Nobody can administer injurious drugs to the animals. Then nobody is going to convey it in a vehicle in a cruel manner, in the sense that a lot of times we see that when the animals are being transported from one place to the other, they're very small cages in which a lot of animals are filled in only, and they're treated as cargoes. They should not be treated like that, and they should have breathing space. Then somebody who's keeping an animal in cages or receptacle which do not provide a space for any movement. So keeping them in cages where they're only able to stand and not able to move around properly. Then neglecting or keeping chained dogs. This is with respect to the owners of the dogs who are keeping the dogs chained, who are not letting the dog exercise sufficiently as the relevant breed might require. Then failing to provide sufficient food or shelter to your animals, that is the owner of the animal will be guilty for it. Then leaving contagious animals on roads without any looking over of or that matter. Mutilating or killing unnecessarily with unnecessary cruelty or to fight with other animals, and organizes, keeps or uses, acts in the management of any place for animal fighting. So here in this particular case we are going to do two cases. One, beating, kicking and torturing of animals, and the next is mutilating, killing or harming or treating any animal cruelly at the time of only for entertainment purposes basically. And if we talk about entertainment purposes, we have to see another relevant section, that is section 22, which is restriction on exhibition or training of performing animals. So performing animals, if they are to be kept with a certain organization, then it has to be taken care of the fact that they are properly registered with the concerned authority as per the central government rules. So if we see the exceptions to section 11 of Prevention of Cruelty Act, there are certain exceptions. First exception is at the time of dehorning of cattle or castration or branding or nose roping of any animals. Then stray dogs might be put, the destruction of stray dogs in lethal chambers or by such other methods that are only prescribed methods and only when the stray dogs are creating a menace in the society. Then extermination or destruction of any animal that is essentially that is required by law, and any such destruction of animals for food. So for food we can kill animals, but it has to be made sure that the animals that are killed under this are not killed with undue cruelty essentially. So the minimum pain is given to the animals. Now basis of the exceptions is the doctrine of necessity, and it includes killing animals for food, and it includes also basically training animals for the purposes of military purposes, for the purpose of policing, etc. So two things that are allowed: one for food and second for the training of the animals. So under this act essentially we see that there were a lot of games which were essentially played from the months of January to May, and these games were different. For example, bull cart racing in Maharashtra, in Tamil Nadu Kambala festival, and in Karnataka it was Jallikattu festival. So in this essentially there were races, or there were different varied kind of sports which were taking place in all these states. So an objection was placed by the Animal Welfare Board of India, and the name of the case was the Animal Welfare Board of India versus A. Nagaraja. This is a judgment of 2014. In the judgment of 2014, this is for your information, this is a judgment that has been recently overruled by the current bench. So we shall be looking at the previous judgment before, and then we shall be looking at what were the amendments that took place in the law, and why did we come to the point that we came to today of discussing the Animal Welfare Association Board versus Union of India judgment of 2023. So starting with the genesis of all this, the genesis of the controversy essentially, it is the Animal Welfare Board of India versus A. Nagaraja. In this particular case, it basically the judgment had outlawed the practice of having Jallikattu and other bovine races. Basically, it had essentially said that under Article 21 of the Constitution of India, which gives rights to of life and personal liberty to all the people, that is all the citizens or non-citizens of India, it shall also mean to include the sentient, basically the silent, the people, the creatures who are not allowed to say, or who cannot say anything. So they will be included in the term person, right? So if they are included in the term person, then we cannot go against them. Then they also enjoy the right to equality, and they also enjoy the right to be treated just like humans. So this is what the Nagaraj judgment essentially stated. And if the case is this, then holding Jallikattu, holding Kambala festival, etc., are in contravention of Article 21 and Article 14 of the Constitution. Moreover, the judgment held that it is also in contravention with our fundamental duty laid down under Article 51A, G and H. Whereas G states that it is our duty to protect the natural heritage and the environment and the forest and wildlife, as well as having compassion towards other living creatures. H, that is 51A, H provides that we shall also have a spirit of humanism towards other people and other things in the country. So Jallikattu, if we talk about this sport, Jallikattu was regulated by the State Act that was promulgated in 2009 year. That was declared void in this case of 2014. The Supreme Court stated that bulls are not capable of running like horses. Bulls are essentially, as we discussed, they're considered to be draught animals or pack animals. So the way the anatomy of horses is built up, it is built up for the purpose of running, and bulls and basically buffaloes, etc., are not built for that purpose whatsoever. So that is why it is essential that the Supreme Court noted that it is essential that bulls may not be forced to get into such races. Then the Prevention of Cruelty Against Animals Act, they said, is a welfare legislation, and it has to be interpreted in the favor of the animals and not against it. So if there's a doubt between two provisions in interpretation, the benefit of the doubt is going to go to for the animals and not against them. Here, the Supreme Court exercised its jurisdiction or exercised the doctrine of parens patriae to take care of the animals who are unable to take care of themselves, and therefore outlawed all these festivals and all these races. So here the Supreme Court had also stated that a doctrine of necessity only applies for killing or transport, killing for food or transport, and here we do not have any per se, we do not have any necessity to engage the animals in such sport events. So after this, after the judiciary outlawed the Jallikattu festival, there was a retaliation by the state government. In answer to this, the state government promulgated first of all a notification and subsequently amendment to the Prevention of Corruption Act. So the 7 January 2016 regulation brought some changes to the Prevention of Corruption Act as well as Prevention of Corruption rules. And in this, they defined Jallikattu and bulls race and Kambala in various different, like they introduced in Tamil Nadu, they introduced the definition of Jallikattu. In the Maharashtra legislation, they introduced the definition of Kambala and bullock race in other states, right? So essentially, not only did they define all these festivals and all these sport events, but also they stated that in the case that these events are to be organized, first of all, they are not outlawed, they can be organized legally, and they are an exception to Section 11 of the Prevention of Corruption Act, Prevention of Cruelty to Animals Act. And secondly, they can be there, it is allowed, but at the same time, the organizers have to take care of the fact that there is no unnecessary cruelty inflicted on the animals while these competitions and sports are taking place. So there should not be any unnecessary hitting, killing, harming of animals or being cruel to animals whatsoever. So essentially, if we talk, we shall see a small, briefly the definitions of Jallikattu, bull's race, and Kambala. So Jallikattu is essentially when a bull is held, when a bull is kind of left in the open field. A lot of people run behind the bull in order to tame the bull, and how they tame the bull is by holding the hump of the bull, essentially. Then bull's race is a bullock cart race essentially in Maharashtra, and Kambala is basically a festival in Tamil Nadu, or races in Tamil Nadu, in which buffaloes are made to race. So the arguments that were given in the present case. Now we are coming to the present case, that is the Animal Welfare Board of India versus the Union of India. In this case, the contention, let us quickly have a look at the contentions, and then we'll see the 5 pointers that were discussed and how it was interpreted by the Supreme Court. Firstly, on conferring fundamental rights to animals, the Supreme Court stated that there has not been any precedents as such to give fundamental rights to the animals. So essentially, Article 21, Article 14 cannot be extended for the benefits of the animals, because categorically the word that is used is persons, right? So here we have right now not given any legal rights to animals, and that is why it was held that it cannot possibly be that we give fundamental rights to these animals, particular animals in Jallikattu, bullock cart racing, as well as Kambala. Then the Union of India was at the position that it's a part of the culture, custom, and usage of particular community or geographical area. Before the Nagaraj judgment, the practice was to the contrary, the central legislation, and thus offensive. But the stance of the government changed. Basically, they are saying that essentially the petitioners, the Union of India in this case, stated that essentially it might have been cruel to the animals before 2014, before the amendments took place, before 2016. But after the amendment of 2016, the policy of the government also changed, and the policy of the government is now that we can hold these races, but only taking care of certain measures. Then the Animal Welfare Board stated that sports is unnecessary, but at the same time the counter argument was, first of all, the first argument was inflicting pain is unnecessary, but there are a lot of counter arguments for this. For example, why do people eat animals for food? So vegetarianism is also should also be promoted in that case. So if you talk about it is okay for food, but at the same time it is not okay for sports, then another argument was raised against it, that a lot of people are still using animals for as a mode of transportation, when other mode of transportations, alternative mode of transportations, are also available. So how are we to discern and how are we to divide as to what should be acceptable and what is not to be acceptable, as long as there is no unnecessary cruelty on animals? Then we should not take up, the Supreme Court essentially stated that we should not take up this balancing exercise which has a societal impact in discharge of our judicial duties. Since entry 17 of list 3 was directly preventing cruelty, the states inherently lack jurisdiction. This is one argument that was given by the Animal Welfare Board. Let's see how the Supreme Court answered it. And on the argument that Animal Welfare Board raised, that it is not only dangerous to the bovine animals, but it is also dangerous to the people who are involved in playing of the games, the Supreme Court answered with the maxim of voluntary non-fit injuria, stating that if a person consents to some harm, then it is his prerogative, then it is his choice, and the state cannot do anything in this regard. So essentially, if we see the changes brought in by the amendments of 2016, which allowed which allowed all these races in various states, Earlier, when these Jallikattu and when Jallikattu as well as the bullock cart racing and Kambala racing, etc., were practiced, there were a lot of practices which were offensive, which were obnoxious. At the same, basically, these practices were maiming animals, hitting animals. Some people used to keep small knives and daggers and in order to poke the animals. Then there were some people who were not making the animals eat for a lot of days, and there were times they were seen that because of the fact that these bovine animals were so nervous before the event used to start, that they used to stop cutting also. So in that case, the animals used to starve a lot. And so there were certain activities. Now in 2016 amendments, it was categorically stated that it is allowed that these races and these events can take place, but at the same time they have to be taken place in a very well regulated manner. Otherwise, the people who are organizing and otherwise the people who are participating and using such means to cause cruelty to animals are going to be indicted under the Prevention of Cruelty Act. So let us see the five stances that the Supreme Court took. First thing was that, is the Tamil Nadu Amendment Act referable in pith and substance under 7th schedule of the Constitution of India, or is it a colorable legislation? In this case, the Tamil Nadu Amendment Act, the Supreme Court stated that the Tamil Nadu Amendment Act is not a piece of colorable legislation. It relates to pith and substance of entry 7 of the essentially Constitution of India. So basically, the stance of the Animal Welfare Board was that in order to further cruelty to animals, it is making a legislature, or it is making laws under this, and the permission of this is being given by the concurrent list entry 17, which actually reads as prevention of cruelty to animals. Here the Supreme Court stated that it has to be read, the entry prevention of cruelty to animals, the states can also make law on it. The fact that the states can also make law on it, it has to be read in the sense that the laws that the states have made are not to promote cruelty to animals, but in order to prevent the cruelty that has already been happening in such sports. And also under Article 254 of the Constitution of India, both if anything is written in the concurrent list, both state and center can make laws on it. But if the state is making a law which is repugnant to the central legislation, in this case the central legislation being the Prevention of Cruelty Act of 1960. So if the state is making anything that is going contrary to the central legislation, then essentially the central legislation is going to prevail. But at the same time, there is a catch in this which states that in the case the state legislature has the assent of the president, in that case the state legislature is going to prevail over the central legislation. The Supreme Court found out that in this case the president's assent was duly properly taken, and therefore the state amendments in the rules as well as the Act of Prevention of Cruelty to Animals was in fact correct. The next question that was put in front of the court was, the Tamil Nadu Amendment Act states that it is to preserve cultural heritage of the Tamil Nadu. So is it actually preserving the cultural heritage, or is Jallikattu and Kambala not a part of the cultural heritage of the respective states? In this case, the Supreme Court pointed out that there is no doubt to the fact that these games have been going on from at least few centuries basically. But at the same time, it cannot say basically if it is a part of the culture depends on a lot of geographical factors as well as other factors, the community factors, religion factors, geographical factors, etc. And the judiciary in this case stated that it is for the legislature to decide whether it's a part of the culture, and it would be a case of judicial adventurism if it decides in this area. The next question was, Is Tamil Nadu Amendment Act in pith and substance to ensure the survival and well-being of the native breed of bulls, and in the act in pith and substance relatable to the Constitution of India. So the Constitution of India, they essentially talked about the fundamental duties, that is 51A, G and H of parts of it, and also Article 48. Article 48 basically has two ideas to it. The first idea is in order to promote animal husbandry, in order to promote basically agriculture, animal husbandry, etc. And the other part is to prohibit the execution of milch and draught animals. Milch and draught animals, as we discussed, are bovine animals, essentially calves and cows, etc. So in this case, the Supreme Court stated that in pith and substance, the act is relatable to entry 17 of the list, and therefore the states can make laws on these. So if you can see here, this is a perfect example of bullock cart racing, and previously we saw this is a picture of the Kambala race that happens in Tamil Nadu. This is basically sports in Maharashtra. And if you talk about this is an example of how Jallikattu is played. So this person is trying to tame the bull by holding the hump of the bull. So coming to the fourth issue, does the Tamil Nadu Amendment Act go contrary to basically your fundamental duties also, and could it be said that it is also going against the fundamental rights? This is something that we have already discussed. Fundamental rights do not extend to essentially animals. They extend to only people, whether they are not citizens of the country or not citizens of the country, but they cannot be, by any stretch of imagination, we can say that they extend to animals as well. And at the same time, do the fundamental duties apply? Yes, we are applying the fundamental duties, and it is the duty of the legislature to balance out the fundamental duties with our fundamental rights. And if it is a part of the culture at one stage, and at the other stage the state governments are also ensuring that no unnecessary cruelty takes place while the happening of these events, then it will be considered that the answer basically the Supreme Court gave in negative. Then the last point is the impugned Tamil Nadu Amendment Act directly and contrary to the judgment of A. Nagaraja? So is it basically in contravention to A. Nagaraja, and is there the review judgment dated 16 November 2016 in the aforesaid case, and whether the defects pointed out in the aforesaid two judgments could be said to have been overcome by the Amendment Act? In this case, the Supreme Court clearly laid down that the defects pointed out in Nagaraj judgment were overcome by the Amendment Acts, essentially speaking that whatever defects were there because of which Jallikattu and all these basically sports were outlawed in the states were now the state government had properly made amendments, properly regulated the sports in order to facilitate the happening of these events, and therefore no unnecessary cruelty is now taking place, at least not allowed by law. So this is all with respect to the current judgment, the Animal Welfare Board of India versus Union of India. We'll come next week again with some other interesting issues. In the case you want to hear our opinion and our, in order to for you to understand any particular topic, you can comment in the comment box, and you can always write to us our doubts. So if you did like the topic coverage, you please subscribe to the channel and like the video. Thank you, and see you again.